A massive wave of gun law changes is happening right now in February 2026, and most gun owners have no idea. Courts across America just made decisions in the past few weeks that could flip everything you thought you knew about your Second Amendment rights upside down. And if you miss what I'm about to explain, you could accidentally walk into a legal nightmare. Quick question before we continue. Are you subscribed yet? No? Then you're missing out on updates that could keep you out of legal trouble, because what I'm about to reveal affects gun owners in every single state. And the next 90 days will determine whether your rights get stronger or get crushed. Hit that button now. Here's what just happened. In the past 2 weeks alone, federal courts handed down multiple rulings that are reshaping gun rights across the entire nation. We're talking about decisions on where you can carry, who can own firearms, what counts as protected speech when it comes to guns, and even whether marijuana users can be armed. This isn't some small technical change buried in legal paperwork. These are massive shifts happening right now in February 2026 that will affect millions of gun owners. Let me break down exactly what's going on and what it means for you. First thing, the Supreme Court is about to decide if you can carry your gun into private businesses without asking permission first. The case is called Wolford versus Lopez, and it centers on a Hawaii law that flips the script on how carrying works. Here's what Hawaii did. They passed a law saying you cannot carry a firearm onto private property that is open to the public unless the owner gives you permission first. That means stores, restaurants, gas stations, shopping malls, all off limits unless there's a sign saying guns are welcome or the owner tells you it is okay. Now you might be thinking, wait, isn't that how it already works? Not exactly. In most states right now, the default rule is the opposite. You can carry into private businesses unless the owner posts a sign saying no guns allowed. Hawaii reversed that. They made no guns the default setting. And gun rights groups sued, saying this violates the Second Amendment. The Supreme Court heard arguments on this case back on January 20th, 2026, just a few weeks ago. And here's why this matters so much. If the Supreme Court strikes down Hawaii's law, nothing changes for most of us. But if they uphold it, every single state in America could pass similar laws, making it illegal to carry into private businesses without explicit permission. Imagine having to ask every store owner if you're allowed to be armed before you walk in. That's what's on the table right now. The decision won't come down until June, but the oral arguments from January showed the justices are seriously considering both sides. Some justices argued that property owners have the right to set default rules on their own land. Others pushed back, saying this destroys the right to carry in public that the Supreme Court already protected in the Bruen decision from 2022. Here's the part nobody's talking about. If Hawaii wins this case, it won't just affect businesses. The same logic could extend to parks, beaches, parking lots, and any other private property open to the public. Your concealed carry permit could become almost useless in states that adopt Hawaii's approach. Second, a major decision just dropped on February 12, 2026 about ghost guns. The Third Circuit Court of Appeals ruled the computer code used to 3D print guns is not automatically protected as free speech under the First Amendment. This came from a case involving a company called Defense Distributed, which sells computer files that let people print their own firearms at home using 3D printers. New Jersey cracked down on this company back in 2018, sending them a cease and desist letter and passing a law making it illegal to distribute ghost gun code without a license. Defense Distributed sued, claiming this violated their First Amendment right to free speech. They argued that computer code is speech, and the government can't ban speech. The appeals court said not so fast. They ruled that not all computer code counts as protected speech. The court said that purely functional code, meaning code that just does something without expressing ideas, doesn't get First Amendment protection. And because Defense Distributed didn't provide enough detail about what their code actually contains, the court couldn't determine if it's expressive enough to be protected. Why does this matter to you? Because this ruling sets a precedent that could make it much easier for states to ban the distribution of 3D gun printing files. If you're interested in building your own firearms at home, or if you believe in the right to manufacture arms, this decision is a major setback. New Jersey won this round, and other states are likely to follow with their own crackdowns on ghost guns. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. The laws I'm covering vary by state and change frequently, so make sure you verify everything with a legal professional in your area. Third, on that same day, February 12, 2026, another federal appeals court heard arguments that could determine whether millions of Americans get their gun rights back. The case is called Williams versus the Attorney General, and it involves a Pennsylvania man named Edward Williams who lost his Second Amendment rights over a DUI conviction from 2005. Here's the crazy part. Williams only got 90 days of house arrest for his DUI. But because the crime could have carried up to 5 years in prison, federal law says he's permanently banned from owning firearms. That's right. Even though he served just 90 days at home, he lost his gun rights for life because of what the sentence could have been, not what it actually was. Williams sued in 2017, and in 2023, a federal judge ruled in his favor, saying there's no historical tradition of disarming nonviolent drunk drivers. The government appealed, and the Third Circuit just heard arguments on this case on February 12, 2026. The government's argument is wild. They're saying Williams should have applied to a federal program that restores gun rights before going to court. The problem? That program has been inactive since 1993. The Trump administration just started reviving it in 2025, and the online application isn't even open yet. The judges didn't seem to buy the government's argument. One judge compared it to the pardon power, where the president has total discretion, there's no real judicial review. The judge pushed back, asking if this program is really any different. If Williams wins, it could open the door for thousands of people with old nonviolent convictions to get their gun rights restored. If the government wins, people like Williams will have to navigate a bureaucratic restoration process that may or may not work, instead of being able to challenge the law directly in court. If you're finding this helpful, imagine what you'll learn in my next video about the exact words to say when cops ask if you're carrying. I break down the legal scripts that protect your rights during traffic stops and police encounters. Subscribe so you don't miss it. Fourth, the Supreme Court is also about to decide whether marijuana users can own guns. The case is called United States versus Hemani, and oral arguments are scheduled for March 2nd, 2026. This case involves a federal law that makes it illegal for anyone who is an unlawful user of or addicted to any controlled substance to possess firearms. Here's what happened. The FBI raided Ali Daniel Hemani's home and found a handgun, 60 grams of marijuana, and some cocaine. The government charged him under federal law for being a drug user in possession of a firearm. Hemani argued the law is unconstitutional as applied to him because he's just a casual marijuana user, not someone who's impaired or dangerous. The Fifth Circuit Court of Appeals agreed with Hemani and struck down the law as applied to marijuana users who aren't currently impaired. The court said occasional marijuana use doesn't justify stripping someone of their Second Amendment rights permanently. The Supreme Court took the case and will decide if this federal law can survive under the Bruen test. Remember, Bruen says gun laws have to be consistent with America's historical tradition of firearm regulation. The government argues there's a long history of disarming habitual drunkards, and that same logic applies to drug users today. Hemani's lawyers fire back saying the government's argument is way too broad. They point out that by the government's logic, anyone who drinks beer or wine a few days a week could be disarmed. They say occasional marijuana use, especially in states where it's legal, shouldn't cost you your constitutional rights. This case is huge because marijuana is legal for recreational use in 24 states as of 2026, and it's legal for medical use in even more. If the Supreme Court upholds the federal ban, millions of Americans in legal marijuana states could be committing federal felonies just by owning a gun and using cannabis, even if they're never impaired at the same time. The decision is expected by late June 2026, and it could completely reshape how drug use and gun rights interact. Fifth, there's also a massive fight happening right now over sensitive places. Courts are trying to figure out where states can ban guns in public. We're talking about parks, libraries, zoos, public transportation, and places where alcohol is served. The Third Circuit just heard arguments on February 12, 2026, about New Jersey's law that bans guns in 25 different types of sensitive places. Gun rights groups argue this is so broad it basically bans carrying everywhere. New Jersey argues there's historical tradition for restricting guns in places where people gather for specific purposes, like education or recreation. The judges asked tough questions. One judge asked why zoos and libraries count as sensitive places, but not bakeries. The state's attorney said it's based on historical tradition. Locations where people gathered for literary and scientific purposes were understood as sensitive at the founding. But here's where it gets interesting. Another judge brought up the 2019 Dayton, Ohio shooting, where 9 people were killed in 32 seconds. She asked why it's unreasonable for legislatures to consider places where mass shootings could happen as sensitive locations. The gun rights attorney pushed back, saying that logic would make everywhere sensitive, which would destroy the right to carry in public entirely. This issue isn't going away. The Supreme Court specifically avoided deciding the sensitive places question in the Wolford case, which means it's still up for grabs in future litigation. Sixth, several other major gun rights cases are pending at the Supreme Court right now, waiting to see if the justices will take them up. These include cases about semi-automatic rifles like the AR-15, large capacity magazines that hold more than 10 rounds, minimum age requirements of 21 to buy guns, and whether felons convicted of nonviolent crimes can ever get their gun rights back. The justices have been holding these cases for months, which usually means they're waiting to see how the current cases turn out before deciding what to take next. Some of these issues have deeply split lower courts, with different circuits reaching opposite conclusions. For example, Some courts have said AR-15s are protected by the Second Amendment because they're in common use. Other courts have said they're too dangerous and unusual to be protected. Some courts have said large capacity magazines aren't even arms under the Second Amendment. Other courts have said they are arms but can still be banned based on historical tradition. The Supreme Court is going to have to step in eventually and settle these splits. The question is when. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the thousands of gun owners who get these updates first. Click subscribe. 7th, state legislatures are also making changes right now. Virginia just passed a sweeping gun control package in early February 2026 over Republican objections. The package includes new restrictions that would be punishable as Class 1 misdemeanors with a 3-year prohibition on purchasing or possessing firearms for violations. Meanwhile, New Hampshire just voted down a red flag law bill that would have allowed courts to order the surrender of firearms by people deemed dangerous during mental health crises. These state-level battles are happening constantly, and they show how divided the country is on gun policy. 8th, the ATF just finalized a major rule change that took effect on January 22nd, 2026. The new rule revises the definition of unlawful user of or addicted to controlled substances. This connects directly to the Hemani case I mentioned earlier. The ATF is trying to clarify what it means to be a drug user who's banned from owning guns, but the Supreme Court may strike down the entire framework in a few months. The timing here is fascinating. The ATF is putting out new rules at the same time the courts are questioning whether those rules are constitutional at all. 9th, there's a push in Congress right now for national concealed carry reciprocity. House Resolution 38 would require every state to recognize concealed carry permits from every other state, just like driver's licenses. This has been introduced before and never passed, but with the current political makeup of Congress, it has a better chance than ever. If this passes, your concealed carry permit from Texas would be valid in New York, California, New Jersey, and every other state, even if those states normally don't issue permits to non-residents. This would be the biggest expansion of gun rights in decades. 10th, legal experts are now saying that Second Amendment jurisprudence is a mess. There's an article from SCOTUS blog in January 2026 with that exact headline. The problem is that the Bruen test, which requires laws to match historical tradition, is really hard to apply. Courts are struggling to figure out what counts as historical tradition, what time period to look at, and how similar a historical law has to be to a modern law. Some courts focus only on laws from 1791 when the Second Amendment was ratified. Other courts look at laws from the Reconstruction era in the 1860s. Still others consider laws from the early 1900s. There's no consensus, and the Supreme Court hasn't given clear guidance. This uncertainty means that identical gun laws are being struck down in some states and upheld in others, depending on which judge you get and which historical sources they find persuasive. It's creating chaos for gun owners who don't know what the law actually is. This information could literally change in the next few months. Subscribe now because my next video will explain exactly what you need to do before these deadlines hit. The Supreme Court decisions coming in June 2026 could reshape everything. So here's what you need to remember. The next 4 months are critical for gun rights in America. We have 2 Supreme Court cases being decided by June that could expand or restrict where you can carry and who can own firearms. We have multiple federal appeals, courts reshaping the landscape on sensitive places, ghost guns, and restoration of rights for people with old convictions. We have state legislatures passing new laws and Congress considering national reciprocity. The legal ground is shifting under our feet right now in February 2026. And if you're not paying attention, you could end up on the wrong side of a new law without even knowing it. My advice, stay informed. Follow these cases closely. Understand what's happening in your state. And most importantly, know your rights under current law before the courts change them. Look, I spend hours researching this stuff every week so you don't have to. The least you can do is hit subscribe to support the channel and make sure you never miss an update. These aren't just academic legal debates. These are real cases affecting real gun owners right now. One court decision could make your concealed carry permit worthless in half the country, or it could make it valid everywhere. The stakes have never been higher. Before I go, remember, this is for educational purposes only. I'm not your lawyer, and this isn't legal advice. Gun laws vary wildly by state and change constantly. Always consult with a qualified attorney in your jurisdiction before making any decisions about firearms. And if you're ever unsure about whether you can legally do something with your gun, don't guess. Ask a lawyer. The cost of being wrong is way too high. Thanks for watching, and I'll see you in the next video where we dive deep into exactly what you should say and should not say when law enforcement asks about your firearm. It's a script that could save you from criminal charges, and every gun owner needs to know it. Hit subscribe, and I'll catch you next time.